a very practical problem that occurs when the first spouse dies. They fund their bequests to the bypass trust. That's easy. And then they fund the rest to the marital deduction trust. And the problem with the marital deduction trust is all it does is postpone the estate tax to the death of the surviving spouse. And so what happens is the surviving spouse in the Q-tip trust gets a substantial bequest, and all those assets are in the trust. And guess what? They appreciate in value. And if the surviving spouse lives 10, 15 years, the assets can more than double in value. So the problem is what Chris is going to do is you have a GST, you have a trust that's exposed to generation skipping. You're going to be able, you're going to end up increasing the generation skipping. So Chris is going to tell you all the problems and then try to come up with some solutions. Okay.
I will be speaking on Friday, September 27th at 8 a.m. My title is Moving Time Overcoming Too Much into GST Vulnerable Trusts. The conversation that I plan to share relates to a couple of big themes and then a couple of smaller nuanced approaches for planners. Importantly, and perhaps differentially, the issues I will address do not depend on the extension or the expiration of the Tax Cuts and Jobs Act in 2026. I'm sure the audience is very familiar with and heard enough about slats and other reciprocal trust doctrine issues and those types of things to be kind of tired of those issues. Instead, I'm going to focus on transfer tax issues of generation skipping transfer tax as applied to GST exempt and GST vulnerable trusts. One example I regularly face at the JP Morgan Private Bank is very large Q-tip marital trusts. The risk of the deemed gift under Code Section 2519, which causes a deemed gift if a portion of the spouse's qualified income interest is ever gifted away. Even $1 of a gift will cause the entire trust to be considered a gift of the entire trust that the beneficiary is making. Of course, there's also GRAT remainder trust, which of course cannot be GST exempt because of the estate tax inclusion period during the term of the GRAT. The Q-tip marital trust is particularly intriguing because of the abundance of wealth that runs through revocable trusts and the inevitability of funding large Q-tip trusts to defer the estate tax until the second of the spouses passes away. Because of the likely asset size and the limited GST exclusion, these trusts are normally not GST exempt, so they're GST vulnerable. But this could lead to some great planning opportunities with these trusts. I'll be discussing that at the Institute, of course, in more depth. But of course, the May decision, U.S. Supreme Court decision in Annenberg, tax court decision in Annenberg, was very helpful in telling planners additional ways to plan with these marital Q-tip trusts. I'm going to focus also on the income tax ownership of trusts under Code Section 678. The use of an entirely owned trust to transact with the owned trust is the key to movement of appreciating assets between and arranging assets in the proper trust. I think the flexibility down the road that could be inserted into the trust to do some of this planning is somewhat in jeopardy because of the CCM 2023 52 2018 that was given to us last year, in which the assistant chief counsel gave us indicated that a change of a trust with beneficiary consent could subject that change to a deemed gift treatment in favor of the grantor or in favor of the beneficiary, depending on the issue that is subject to the consent. I think that leads to a great risk to establish GST trusts where the beneficiaries could be the most recent transferor for generation skipping transfer tax and thus blow up some already great planning. So there's risks to these operations: fiduciary risk, IRS risk, assignment of income. I'm going to discuss all these risks as part of my presentation in September. I'm not going to go over specifically the nuances of the complex GST exempt system. Steve Bono, who's going to be speaking later that day on September 27th, is going to go into those nuances, and I look forward to his presentation. I believe that in addition to the CCM I already mentioned, there's several other cases that bear on planners and what we need to be mindful of and the opportunities we can capture. The U.S. Supreme Court's decision in Loper Bright Enterprises versus Raimondo, invalidating the Chevron doctrine and could lead to greater arguments against some of the really draconian IRS rulings and interpretations. Similarly, the Rev Rule 2024-14 dealing with the IRS's focus on partnership basis shifting among related parties could change the way we think about some of the operations that we're engaging in. I think it's a tremendous time period to be in the transfer tax planning environment. And my hour-long talk on September 27th won't focus hardly at all on the Tax Cuts and Jobs Act. I hope that the value that I can provide in this presentation for all planners will lead to additional considerations for every trust, whether they're revocable or irrevocable. So I look forward to seeing you on September 27th.
Wow.
It's a great topic. It'll be interesting to hear his comments on Loper and some of the regulations, regulatory guidance that he feel may be vulnerable because of that. That's something that the profession is still grappling with, and I haven't seen much on it yet.
Yeah, and there's so many large Q-tips that need to be handled. So that's just a lot of really important stuff.